Bam! Good evening, I'm attorney Vince Davis, and this is the evening office hours. Every evening, Monday through Friday at 8:30 p.m. I answer one of your questions that you might have and you posted or you emailed me, and in some cases, you text me. And this is the question for this evening. Mr. Davis, I'm the grandmother on the mother's side, the maternal grandmother. Why won't they let me come into the courtroom when they're doing the cases? It's a very good question. And California, as I can imagine most states, have made a rule as to who's entitled to be present at a juvenile court hearing in the Juvenile Dependency Court, or otherwise known as the CPS court. So, the persons that are entitled to be present are the child and the non-minor dependent. Makes sense, they're a party to the case. Next, all parents, all de facto parents, American Indian custodians, and the guardians of the child, or if no parent or guardian resides within the state, or if their places of residence are not known, any adult relatives residing in the county, or, if none, the adult relatives residing nearest the court. Now, my reading of that rules means that if you're a grandparent and you show up to court, and usually some bailiff tells you, oh, you can't come in, you should request that the court allow you to be present under California Rules of Court 5.530, Subdivision B. The next on the list is the attorneys representing the child or the parent or the de facto parent or the attorney of an adult relative or an Indian custodian or tribe of an Indian child. The social worker is allowed to be present. The prosecuting attorney, which in most counties in California, say, is the county counsel's office, but I think San Francisco, the city and county of San Francisco, has, I think, the city attorney's office. The court-appointed special advocate, otherwise known as the CASA, a representative of the Indian's tribe, the court clerk, the official court reporter, and of course, the bailiff at the court's discretion. Now, a person or a parent who is incarcerated has to be present in the courtroom, or that person has to sign a waiver saying that they waive their right to appear. And one of the things I didn't know, which I found out in researching this question, is that the incarcerated parent can appear by way of telephone if the technology exists, or by other technology if the technology exists. And I think after COVID, almost every courtroom in the county of Los Angeles, and probably in the state, now has the ability to have people appear by phone or by Zoom or by WebEx. And I know in Alameda County they've been using something called Blue Jeans, but it's all the same. It's technology for the person to appear in court without physically being present. So if you're an incarcerated parent or know of an incarcerated parent, please mention that to him or her. Because I've had people tell me, well, Mr. Davis, I didn't want to come to court because the warden or the warden's representative told me I would lose credits for my good time to get out early if they had to transport me down to Los Angeles County and turn me over to the sheriff's department and had me stay in county custody versus state custody. I've never really researched that issue, but it seems to me that you shouldn't be penalized, or you can't be penalized on the issue of losing credits because you attend a court hearing regarding your children. Now, The proceedings in a juvenile court hearing are confidential.